All right, I'm going to call to order the meeting of the Sentencing Guidelines Commission. This is January 11th, 2024, and I will ask Nate Rice to read the roll.
Roll call, Vice Chair Larkin.
Present.
Larkin present. Crutchfield.
Here.
Crutchfield present. Fraze.
Here.
Fraze present. Knutson.
Present.
Knutson present. Ladd.
Present.
Ladd present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Morath.
Present.
Morath present. Morin.
Present.
Morin present. Mueller.
Present.
Mueller present. Reeves. Reeves absent. Saxena.
Here.
Saxena present. Chair Mitchell.
Here.
Chair Mitchell present. Madam Chair, there are 12 members present, 1 member absent.
All right, and with that, we have a quorum. I guess I forgot to say Happy New Year. It's the first time I've seen you all this year. It feels like it's already been a month, but Happy New Year. First item on the agenda is approval of the draft meeting agenda. So I'd entertain a motion to approve the agenda. Commissioner Middlebrook makes that motion. Commissioner Ladd seconds it. Go ahead and read the roll. Oh, any discussion on the agenda? Hearing none, we can take the vote.
To the Middlebrook motion to approve the agenda, Larkin.
Yes.
Larkin, yes. Crutchfield.
Aye.
Crutchfield, yes. Fraze.
Here.
Fraze, yes. Knutson.
Aye.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Morin.
Yes.
Morin, yes. Mueller. Mueller, yes. Reeves. Reeves absent. Saxena.
Yes.
Saxena, yes. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Third item on the agenda is approval of the draft meeting minutes from December 14th, 2023. They were sent out a week ago, so you should have all had a chance to review them. I would entertain a motion to approve the minutes. So moved. Commissioner Larkin makes that motion. Commissioner Crutchfield seconds. Any discussion on the minutes? Hearing none, we'll take the vote.
To the Larkin motion to approve the December meeting minutes, Larkin.
Yes.
Larkin, yes. Crutchfield.
Aye.
Crutchfield, yes. Fraze.
Yes.
Fraze, yes. Knutson.
Aye.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Morin.
Yes.
Morin, yes. Mueller.
Yes.
Mueller, yes. Reeves. Reeves absent. Saxena.
Yes.
Saxena, yes. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right, item 4 is what we're actually here for today, which is approval of the draft 2024 report to the legislature. This is due on January 15th, so we will not leave till we approve the report today. I don't think it'll take that long, though. I'm going to turn it over to Director Wright to walk us through that.
Madam Chair, unless something goes terribly wrong, I will not be at work on January 15th, being a holiday. So the date on this is January 12th, which is tomorrow. So welcome to provide any edits or inputs that you like, but we do ask that they be limited if possible, because we do have to incorporate these all into the document and send them out to the chairs and members of the House and Senate crime committees as required by law. So that's the House Public Safety. Yeah, there's more to it. I've been out of the legislative swing for so long, I've forgotten what the full name of the committee is. But the House Public Safety Committee and then the Senate Judiciary Committee, those are the two committees that have direct jurisdiction over crime, and those are the committees that we're required to report these to. So we will be emailing those out tomorrow. This is really the third time this has come before you. The first time it was simply the data report. You may remember a PowerPoint presentation back in November, and then the second time it was looking at the report. And so I'm not going to go over everything today. I'm just going to go over the things that are highlighted. The things that are highlighted indicate changes. It's not written up in marked up language, but it does alert you to the areas that we've highlighted. or that have changed, and obviously staff draft will be gone. There was some page numbering that's not highlighted here. We did fix some page numbering, so it's small Roman numerals at the beginning, and then it starts with page 1 once the report actually starts with the introduction. On the executive summary on page 3, so that's page 3 of the current draft, not of the December draft, if you're comparing, it discloses how many reports of firearms cases the county attorneys gave us, and as we'll talk about later, this was a record high number, 1805. And it was a record high number even without the additional counties that have come in since we last met. The next change is just some language regarding some introductory language in the labor trafficking rankings on page 6. Moving on then, so really not a lot of changes in the text of the report with respect to the commission's work, which is really the heart of the report, or the commission's recommendations to the legislature. We did add a paragraph here. I think this is an entirely new paragraph. We realized we're introducing the commission staff as a 7-person staff, which is new. It's always been a 6-person staff. So we added a paragraph here that explains the addition. So it talks about Ann Wall's retirement, which normally we don't talk about staff members by name, but being that she served the state for almost 4 decades, we thought it was worth talking about her service. And then the fact that we were understaffed, but the legislature did fund a new research supervisor position that's been filled, and we are working on resolving the staffing shortfall and making great progress, as I'll talk to you about later in the meeting if there's time. We also changed some language on the some training language. One of the sentences just didn't make sense, and there was some incorrect information. So that's been changed on page 13. This was a comment that came up last time. So figure 2 used to have a blue line and a green line, where the blue line was the number of cases over time, and the green line was the population over time. And the suggestion was made, why not just say what you're trying to say, which is that although the rate has risen, it hasn't, one explanation for why the number of felony cases has risen would be, well, the population of the state has risen. But the point of the blue line versus the green line was, well, you can see that the population hasn't risen as much as the number of cases have risen. So what figure 3 does is it takes the population into account. So figure 3 is figure 2, but population adjusted. And you can still see that it's rising. In fact, figure 2 and figure 3 don't really look that much different, but the slope is a little more gentle on figure 3 because it does take population increases into account, but it's still an upward slope. It's pretty clear, steady increase with the exception of a few bumps in the road and most notably the big COVID blip in 2020. And then there's some text that explains the new figure.
I asked for, I was one of the people who was confused by that graph. I really like the way that you've chosen to explain that. I think this is really well done. So thanks for working on that.
The next year just explains the other offense category a little bit more. It said crimes against the government. If you actually break down, and this is not that detailed of a data report, but if you look at our full data report that will be published soon here, hopefully, you can see the breakdown in the other offenses. So basically, to recap, we have person offenses, drug offenses, property offenses. Those are the big 3. And then we have felony DWI, non-criminal sexual conduct, sex offenses, child pornography, for example, weapon offenses, and then the catch-all other category. And the runaway leader in the other category is fleeing a peace officer in a motor vehicle. So before it said, for example, crimes against government, this is a little bit more specific. And that category was up 24%. A little, in the footnotes, some clarifications about the offense category, including the other offenses. I think the paragraph, if I recall correctly, the paragraph on page 19 involving weapons offenses, I think that's new. I think that was just an oversight that we didn't have a descriptive paragraph on weapons offenses. So that's a new paragraph. Let's see, moving on. Just some verbiage changes there on page 20 and 21, I would say. Figure 7 on page 22.
I think it didn't have the legend.
Yes, I think that was your catch, Madam Chair. I think you pointed out we missed the legend, which is kind of important.
Yeah.
Then moving on to felony incarceration rates in figure 8, that was also the chair's suggestion that we put in some percentages there to make clear what we're talking about. In figures 10 and 11, we changed state prison to actual prison, which is what we say in the text anyway. And it's the point of saying actual prison is to compare it to presumptive prison, because both figures 10 and 11 talk about presumptive versus actual prison. So I think that's helpful. Also true in figure 12. All right, some changes to footnote 35. All right, so this is the new figure that we mentioned that we were going to have at the last meeting. This is the mitigated dispositional departure rates over time. You may recall in the big 5 slides that I did when we were kicking off the comprehensive review, I had this chart in there, and we thought, well, why isn't that chart in our report? So this is showing the mitigated dispositional departure over time for presumptive commit cases, which is, we do have information about mitigated dispositional departure rates as a total of all cases, but really its significance is in the universe of presumptive commit cases, because those are the only cases where there's a possibility of getting a mitigated dispositional departure. And so this is the percentage of cases in each year where the guidelines recommended prison, but that was not the presumptive. That was not the actual sentence that was imposed. Instead, a state sentence was imposed. And we have also some language explaining that over time. So I think that was something that really was missing from our reports, and I think that'll be a good addition going forward. All right, so I think that takes us. Some explanation about the geographical variation in mitigated durational departure rates. I think that was brought up at the last meeting. And that takes us to the county attorney firearms section. We did have, these changes are all due to additional counties reporting. I want to thank our member, Kyra Ladd, for being really involved in this, as well as Bob Small, the executive director of the County Attorneys Association. Carjacking was added to the list of 611 offenses, really just because carjacking is robbery. But everything else here is pretty much, footnote 37, it was a little hard to understand, so we reworded that. But otherwise, pretty much everything here is just updated data. So if you look at table 6 on page 42, you'll see that there are still a few outstanding counties that did not report. Looks like 3 counties, if I'm 4 counties, okay.
Did not report?
Oh,
Yeah.
did not report. So 4 counties that did not report.
They're on your list.
They're on my list, yeah.
So, I mean, I guess if we get them tonight, we'll probably put them in tomorrow. But,
I've harassed them and harassed them and harassed them, and apparently I don't have enough harassing power over them, so I tried.
Okay, in a non-criminal sense, I'm sure.
Yes.
So, yeah, so that's You know, I guess we've done worse for sure. I will say, since Bob Small became executive director, he's kind of, I don't know, he must have some pretty good harassing power because
He's
we've
very
actually,
persuasive.
we've had some years where we got 87 out of 87, which was really, really good. I mean, you know, that's 87 counties. It's a lot of counties. So tip of the hat to the County Attorneys Association and Kyra Ladd for getting the counties we did. So the appendices, I don't think there were really any changes to those other than very, very minor changes. Those are just reporting all the changes to the sentencing guidelines. There were no changes that we're proposing to the sentencing guidelines this year, so that's a little unusual. We're just, so there's really, that's one of the two big categories of changes besides the county attorney's reports that we are required to report. One is changes that happen in 2023, and then the second is proposed changes that are to take place on August 1st of 2024. There aren't any this year, which is unusual. So I think that's the end, Madam Chair. Unless there are any questions, I would ask for any edits, and then subject to any edits to adopt this report.
Any questions or edits that people want to offer?
Well, it just seems to me, it's just a wealth of information, kind of recap of the year. It seems like annually that there's improvements, additions, clarification. It's very useful. I hope the public understands that this is available. The legislature uses it.
Yep. Any other comments? All right. Other than great work as usual to the staff, and thank you so much for pulling it together. And I also really appreciate that you've pulled so much of it together early so that this is not the first time we're seeing it. That's really been helpful to help us digest the information and meaningfully engage in the preparation of the report. So I do appreciate that.
Well, I would pass those comments along, but everybody's online, so on behalf of the staff, thank you.
And with that, I would entertain a motion to approve the final report. Commissioner Middlebrook?
Thank you, Madam Chair. I would move to approve the draft of the legislative report.
All right. And Commissioner Moore seconds. Do we have any discussion? Before we vote, I want to recognize that Commissioner Reeves has joined us today. Not to put you on the spot, just when he calls in your name, you'll be answering. I just want to make sure it's on the record that you're here.
Madam Chair,
Anything else?
yeah, just I wondered that, and I should have asked for this earlier, but if we do find any editorial, minor editorial changes, if the motion would encompass that, and if any of the four stragglers report tonight, I think we can probably add those in.
Commissioner Middlebrook, does your motion encompass authorizing staff?
Yes,
to make
it
those
does.
changes? And Commissioner Moore, do you accept that amendment?
Yes.
All right, so that's the revised motion.
All right. To the Middlebrook motion to approve the 2024 report to the legislature as drafted by staff with authority for staff to make minor editorial changes if necessary. Larkin?
Yes.
Larkin, yes. Crutchfield?
Aye.
Crutchfield, yes. Fraze?
Yes.
Fraze, yes. Knudsen?
Aye.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 13 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Awesome. All right, so now we move on to a presentation by Professor Wright. So I'm going to invite you to come up here, Professor Wright. As he's coming up, we are going to be transitioning in the next meeting or two to really starting to take control of the comprehensive review, starting to set what are some of the first things we want to work on. And we have a number of new members. So to me, it struck me that it would just be helpful to continue to get perspectives on things we could be thinking about. Doesn't mean we have to think about anything that comes up today, but things that we could be thinking about. So Professor Reitz has done a lot of work on guidelines over his career. He is the author of the Model Penal Code for Sentencing. It seemed useful to have him come in and give us some perspectives that we could start to think about. And with that, I am going to, whenever you're ready, Professor, hand it over to you.
Okay, I think I'm ready. Thank you, Madam Chair. And I should just say preliminarily, it's an honor to be here. This project is 11 days old, but my relationship to the Minnesota Sentencing Guidelines goes back to 1989, when it was the state system that convinced me that judicial sentencing guidelines were not only a good idea, but were a crucial area of reform for United States criminal justice policy. So I've followed the commission for a long time, and to be part of a project working in collaboration with the commission is just a dream project for me. So I'm grateful to be here and talk about Minnesota, talk about the Model Penal Code.
And what I just have to do one thing, Professor Reitz, because I have to show everybody this is what he's talking about when he's talking about the Model Penal Code. It's a giant book. He did all the work that goes in here. I'm going to let you talk about whether or not we get to look at those, but it's a big piece of work. So this presentation cannot encompass everything that's in here today. So you can tell us how you decided to focus it.
Oh, dear. Well, yeah, I mean, the Model Penal Code it's 1,100-page book. It was a 15-year project sponsored by the American Law Institute that involved a survey of what every state in the country was doing around various sentencing policy and legal issues, and trying to draw out the best features of the different states. We're trying, and I should say that Minnesota was the state that we relied on most heavily, although we found quite a few other promising ideas in other systems as well, particularly other state systems that have adopted some version of the Minnesota guidelines since first implemented here. The book you see came out in 2023. The actual provisions of the Model Penal Code were approved in 2017, but then there was a lot of commentary and research and background information that needed to be added before the final publication. So I've asked the ALI, the American Law Institute, to donate several copies to the Sentencing Commission, the Minnesota Sentencing Commission, so that members of the commission and staff have access to it if you want. Okay. Now, in these slides, the Model Penal Code sentencing will be referred to as MPCS, because that's just easier. And briefly, the American Law Institute is a nonprofit that's existed. I think it's just cleared the century mark, that produces law reform materials, or actually model statutes for states largely, and also produces something called the Restatement of Law, which every law student knows about. Every law student will study the Restatement of Torts, the Restatement of Contracts. Every law student will study the Model Penal Code during their training. The original Model Penal Code was finished in 1962, and like this new volume, was composed of recommendations to state legislatures. So the Model Penal Code is not itself a code, really. It's a recommended code. And it was intended in 1962, and the new edition is intended to be the same, to be something that states, if they wanted to, could adopt as a package, but more likely could adopt piece by piece if they found certain parts of it valuable in their jurisdiction. Okay. The original code, with final adoption in 1962, influenced state legislation in 40 states, or maybe more than, at least 40 states. So that at least part of the Model Penal Code recommendations in the first edition of the code became actual state legislation. Now, many states changed the language or adapted a provision to their needs, so it wasn't exactly the same. But the original code, I think, no question, is the most successful attempt at sort of recommended criminal legislation in history. There have been many model legislation projects in criminal law, and especially in Britain and even in the U.S. But to influence that many states was a spectacular achievement. In addition to the states, the Model Penal Code is frequently cited by courts, including the United States Supreme Court, as persuasive authority in deciding how to resolve cases. So the original Model Penal Code has been cited by every jurisdiction in the country, by every state, every federal circuit, and the Supreme Court. So even in jurisdictions where a Model Penal Code provision was not formally adopted into legislation, courts make frequent use of it. Again, as persuasive authority, as a source of deep research into particular areas, comparative research across what different countries, what different states are doing. So this current project, which was begun in the early 2000s, was meant to update the effort in the realm of sentencing. The original Model Penal Code in 1962 did speak to sentencing, but as you can all imagine, the world of criminal sentencing has changed completely since 1962. So the American Law Institute decided that this was the area of criminal law that most needed intensive study, that might be most useful to state policymakers and state legislatures, because at the state level, well, practically at any level, no one has the resources to put a 15-year study together. With not just me, there were meetings 3 or 4 times a year. Hundreds of people participated, gave me suggestions, participated in meetings, voted on each edition, each chapter of the code as it was developing, and thousands of ALI members voted on the code before it could be approved. Okay, so it represents this huge effort. And I think the mission of the ALI is to provide resources to states that would never have the resources to do, to mount a kind of project like this. Okay. A lot of the Model Penal Code has to do with sentencing guidelines at the MPCS. A lot of it speaks to every state, including states without sentencing guidelines, but a great deal of it has to do with how to create a sound, a best practices sentencing guidelines system. And in those areas, there's no question the Minnesota sentencing guidelines system was the foundational model, the sort of starting point for what the ALI built in terms of its recommendations. Okay, and I'll talk about this more in a minute. My role as reporter was to write practically everything in that book. 90% of it, I think, I wrote, but nothing that I wrote went into the code until it was heavily critiqued. And there was one year that we argued about 3 lines of the code for an entire year. Right? So there are pieces of the code that were intensively focused on, but all of it went through many layers of consideration and comment and voting and revoting before the code was approved. So my role was to write the first draft of provisions, which then became subject of the process. And what ended up was, in some cases, not necessarily what I first envisioned, often much better than what I first envisioned. But the process involved hundreds of people actively participating. Yes.
Commissioner Knudsen.
Can we ask a question?
Yeah, that'd be great.
This is fast to me. Uniform law commissioners have any input or involvement in looking at this?
No, the Uniform Law Commissioners did create a model sentencing code in the early 1980s that was meant to be a model or a uniform code for the states. And it was never terribly successful because states are so different in their criminal justice context, in the way their institutions are organized, the way their sentencing. So a uniform code, which is what the Uniform Law Commissioners worked toward, what wasn't successful, wasn't influential. And the ALI took the view there shouldn't be a uniform criminal code or a uniform sentencing code. That there should be a model that laid out suggestions and covered areas of greatest importance, with the realization that no one's going to adopt it whole cloth. Right? That probably states are going to pick and choose what to do with it. Maybe the legislature won't adopt anything, but the judiciary will be influenced by something in the code. So the idea that there were principles and recommendations rather than a uniform code of criminal law or sentencing, I think is what kept it out of the jurisdiction of the Uniform Law Commissioners. Now, the ALI is the main partner of the Uniform Law Commissioners for the Uniform Commercial Code, for example. So sometimes the two organizations work closely together. But even in the 1950s, when the first code was launched, there was a recognition that you can't have a uniform product that all states are expected to adopt. There had to be something that was aspirational, that could speak to states and maybe influence one state in terms of probation or economic sanctions, another state in terms of whether to have a sentencing commission or not, but not a uniform state. Does that answer your question?
Yeah, that helps me understand what the ALI is in the book here, what it's driving it.
Right.
As opposed
Right.
to uniform laws.
Yes, and it's useful to think of it this way. I'll be showing selection of some of the provisions of the code in the slides. But when the ALI makes a recommendation or recommends actual language, certainly it was my recognition, and I think within the ALI this was taken for granted, that a state legislature or a court or policymakers who decided to sort of absorb that recommendation would probably use different language. They might change the wording. They might adopt a recommendation incrementally, maybe not do exactly what the ALI had suggested, but go part of the way. So it's meant to be a very flexible kind. I want to use the words thought-provoking document, but I think it really is meant to provoke serious thought and consideration about various issues. But the states that have been influenced by the code so far have changed things around and some of the language has been placed in sentencing guidelines rather than legislation. And that's, I mean, to me, that's very, that's a success of the code.
Let me call in Commissioner Crutchfield real quickly here.
Yes.
And this is a kind of a strange question, but I remember going over the penal code in Professor Brayson's class a million years ago. But our law is based on, a lot of it is on British common law. And I wanted to know if you use that as a base at all, and if the model penal code has affected what they do. It's a tour de force, what you've done. I mean, it's unbelievable in harmonizing what's going on throughout the country and how we look at crimes. But how's it affected things internationally? Have the Brits adopted what we're doing, or what's the interplay there?
Well, there's a lot of interplay. As you say, my version of the model penal code was heavily influenced by comparative research into all 50 states, but also other common law countries, especially Britain. And in 2007, 2008, the British government hired me as a consultant to work on Criminal Justice Act legislation that was enacted in 2009 to create their version of a sentencing commission, which they call the Sentencing Council, and sentencing guidelines. So there's been a lot of cross-fertilization, and I've been asked at academic conferences at Oxford University to give presentations comparing U.S. sentencing guidelines and what the British system currently uses. So the project has learned a lot from other English-speaking countries, and to the extent that research into continental Europe or Canada, Australia, it was accessible to me. I made use of that as well. But I think anyone in England and Wales who is in the realm of sentencing reform and sentencing guidelines would be very aware of this project. They would be very aware of the Minnesota Sentencing Commission, because that's probably the state they look to the most. They've sent representatives overseas to come here to Minnesota from time to time, as have other countries. But I think there's a lot of cross fertilization. And much of what the British did in terms of instituting appellate review of sentences was the basis for the states in the U.S. It's not many states, Minnesota is one, that instituted a meaningful appellate review of sentencing decisions.
Thank you so much. Thank you.
Yeah, it's, okay, well, that's a little bit about what this product is. And I think, originally I was asked to give a presentation on what was in the model penal code that wasn't already in the Minnesota system. A lot of the recommendations in the code are just stolen from the people who created the commission in the first place. Doug Amdahl is someone that I worked with in the late 80s, and Kay Knapp is someone I've worked with for decades. People who were the sort of founders, the intellectual leaders in the beginning of the model of the Minnesota Commission. So there's a lot in the model code that is just taken whole cloth from the Minnesota system. But then there's a lot that we gathered from other states or other countries, or that the ALI decided to recommend, even though no state had yet done that. Okay, so the request to me to talk about what was in the model penal code that is not already a feature of the Minnesota system did roll out a lot of the code, but there's still so much in there that probably is different from what Minnesota does, that I think a better ambition for today's talk is just to introduce you to some of the ideas that are in the code and how they might apply to issues that you have identified as important to the comprehensive review. Maybe raise a couple issues that for your consideration are these possible issues that should be added to the slate of what should be done in the comprehensive review. And as I said, at least in terms of the University of Minnesota, our active participation is only 11 days old. So we can give you a lot of research or a lot of in-depth analysis from the Model Penal Code and other sources if you select certain topics to task us with concentrating on. Okay, so all I can do is give you some illustrations of what kinds of things you might find in the code. I'm confident, no way I'm going to get through all the slides that I prepared for today, but they will be posted on the website and made available to you if you'd like to look through the ones that we didn't get to, but let's see how far we can go. Now, I've already said that the Minnesota sentencing system is really a beacon for many other states and many other countries. I've met impressive people from New Zealand working on sentencing reform in New Zealand. They know all about the Minnesota sentencing guidelines and its history. But just within the Model Penal Code, the original planning documents for the Model Penal Code spoke explicitly in terms of the Minnesota model. This was what the Model Penal Code was aiming towards. That there was no such model in the 1962. And so here's just some language. This is from the original planning doc. And you don't need to read what's on these slides except Minnesota model, Minnesota model, Minnesota model. You can read this when you get the slides, but many express allusions that the Minnesota architecture had been, ultimately in the view of the ALI, the most successful overall institutional architecture for sentencing reform in the United States and continues to be. Okay, but it's explicit, and this is why I take pride in working on this project. I mean, this is a very prominent history in this room and in past meeting rooms. Okay, so let me give you some examples of some of what the Model Penal Code talks about. The first provision in the new Model Penal Code speaks to the purposes of sentencing in the sentencing system, the basic goals that everything else is trying to achieve. Now, I'm not going to go through all of them, but the Model Penal Code expressly took public safety as one of its two most important guiding principles in everything that it did. So in this very first provision, which is numbered 1.02 subsection 2, because that was its numbering in 1962, speaks to the general purposes of sentencing. Okay, and I hope this isn't blocked. And in the provision on sort of utilitarian goals, it speaks to a whole complex of ways to advance public safety through the sentencing system. Now, many of these would be familiar to you, but public safety in the Model Penal Code in this provision is understood as including offender rehabilitation. Anything that reduces future levels of crime is equated in the code with public safety. So offender rehabilitation is a public safety goal. General deterrence, if achievable, is a public safety goal. The incapacitation of dangerous offenders is a public safety goal. And a successful reintegration of people coming out of prison or just having been sentenced and re-entering their communities is a public safety goal. So I think the code is very consistent with discussions in this room on that sort of utilitarian or crime reductive complex of goals for sentencing system. Although the code adds one important principle that I think is worth focusing on, in addition to the what you just saw on the screen. The code in that same purposes provision says, well, one of the main purposes of sentencing is to avoid the use of sanctions that increase the likelihood that the defendant or offender will engage in future criminal conduct. Okay, in our research over many years and working with many jurisdictions before the code was finalized, we observed a number of things in criminal sentencing that we thought were making things worse, not better, or in individual cases were impeding people from successfully reintegrating or rehabilitating themselves. There are three examples on this slide. Probation conditions that are more onerous than necessary, which is a recognized problem nationwide, often make it harder for probationers to keep a job or to travel to work or to meet their family obligations. Probation conditions are often numerous enough that, you know, most of us would at least have difficulty abiding. And so one has to be careful not to actually obstruct rehabilitation or reintegration. The second example is economic penalties that overwhelm someone's ability to just basically to support themselves or their families. In the view of the code, this is potentially criminogenic, to take someone who's already close to the poverty line and then impose unrealistic economic burden. It's important to think about whether a sanction is doing more harm than good. Prison sentences that are unnecessary on public safety grounds usually leave the prison releasee worse off than before the prison sentence was imposed. If prison is justified, I'm all for it. The model penal code is all for it. But in cases if prison sentences are used excessively, that could have a net negative effect, right? So the basic principle added to the code, and I'd like to see this added to the guidelines, is one thing in the mind of judges when they sentence is, let's be careful not to do anything to make it more likely that this person is going to have to turn back to the criminal, the illegal economy to move forward. Now, that same provision that we were just looking at also voices system-wide purposes, more than several of them, but I was just going to point out one right now because Minnesota has been particularly good at this. It's a system-wide purpose to ensure that adequate resources are available for carrying out sentences imposed, and that priorities, rational priorities, are established for the use of those resources. Okay, Minnesota was the first state that demonstrated that this could be done under sentencing guidelines with computer projection models that have turned out to be not perfect, but unexpectedly good when conjoined with guidelines. The code talks a lot about management of correctional resources. When you make a change in sentencing law, that there ought to be reasonable foreseeability in what that's going to mean in prison bed spaces or downstream consequences. Minnesota pioneered the idea that prison population bed space use could be projected and that credible projections could be generated most of the time when proposals to change sentencing legislation or guidelines are on the table. Okay. Now, what the model penal code adds to that is that the responsibility of the sentencing system to manage correctional resources should include the concern that adequate resources for community penalties also be provided. Okay, and I guess you could add in-prison programming as well. The total budget of corrections ought to be used to highest purpose and ought to be funneled to areas of the highest priority within the system as a whole. This, we think, is something that Minnesota has not done well. North Carolina has actually done a pretty good job at this when they've instituted a sort of parallel projections for community corrections demand and prison spaces that have been very useful in their history and some of their so this is something the code might suggest to this commission. At least another state has done this. Is it worth thinking about?
Madam Chair.
I'm sorry, yes, Commissioner Ladd.
Thank you. And I think that the point that you just made is a concern that I've had for quite some time because of the three models of community-based
Yes.
services that we have, and they're not funded equally. And when the funding's not equally, the resources that are not distributed equally in terms of what your options are to do community-based penalties or community-based resources.
Right.
And so how does that get reconciled sort of with the idea of this sort of model plan when you have these essentially three different buckets
Right.
of resources in which you're trying to navigate similar programs, similar, I don't want to say penalties, but processes when those resources simply aren't there for some.
Right. Well, the code does talk about this because most states have some version of this problem. They don't necessarily have the sort of three buckets problem that Minnesota has, but most states have the problem that community corrections are funded largely at the local level, whereas state prison comes from the state treasury. So in order to do this successfully, well, most successfully, you do need to think about budgetary formulas to allocate across the different systems or the different counties or the different buckets in Minnesota. So this is not a problem that a sentencing commission by itself can fully solve. There would have to be some kind of a legislative framework like realignment in California, which has been relatively successful at this kind of thing that creates funding formulas for the different entities that have to pay for community corrections. That makes sense. Okay, so that's one thing that can be done but another thing can be talking to judges or generating principles for community corrections sentencing that are responsive to this idea. I don't know that we'll get to it today, but the Model Penal Code's probation provision is founded on the premise that too many people are under probation supervision, that it would be a better world if we had fewer people under probation supervision, but devoted more resources to each one of those people. There would be a way to prioritize the use of probation spaces in the way that, and an admonition can be given to sentencing judges. Don't impose a probation sentence unless there's a purpose of probation that reasonably could be furthered by the sentence. So you're introducing an idea in the judicial guidelines that might just be a consideration or a different factor to think about for judges that would move in the direction of preserving the use of the resource where it has its highest purpose, if you see what I mean. Okay, so there are indirect things you can do, but the California realignment model is actually a very intriguing a thing to look at it in terms of new funding formulas to move state money to the counties in a way that makes at least some better degree of sense than what most states are currently doing.
But also, I think I heard you, one thing I heard you mention too was that North Carolina is projecting the community supervision impact of legislation as well.
Right.
And we do prison projections, but we don't do supervision projections.
Right.
So I mean, we probably have the data in some ways to do that on the felony side, not for other side, but at least, to see like what's hitting or
Right.
where's it gonna fall. I think Commissioner Larkin, you might have had your hand up.
Well, I was just going to ask, so what does a judge do when faced with an offender and there's really no point of probation?
Right, and this
What's
is
the
in the
alternative?
slides later,
Okay.
but the code talks about various alternatives. The problem is that most judges will tell you that at least some of the time, and in a fair number of their cases, when they give a probationary sentence, it's because they have to be seen to be imposing a sentence that really means something. If you're not going to give a prison sentence or jail time, probation at least sounds like you're doing something, and probation with conditions and probation. So many judges have told me, well, if you take away my ability to impose probation sentences, I think I'm going to end up sending more people to prison because I won't have that, that's my alternative. Now, the code recognizes that's a problem, but it says, well, community service sentences that aren't probationary sentences subject to revocation. There are economic penalties used widely in Europe, like the day fine, which is in many European countries used as frequently as probation is used in the US. In Germany, the day fine is the default sanction other than prison, right? So they have a different, the code recommends that in some cases, judges should be willing to impose a sentence of conviction without further penalty. Okay, and there are actually a dozen states that do this. Canada does this, Australia does this, where the recognition is that a conviction without further penalty by way of prison probation still carries a stigma. It still carries criminal history liability into the future, and it still carries in every state and in the federal system pretty impressive collateral consequences, civil disabilities that are meaningful impact, and those things should be considered. A sentence of conviction without further penalty should in some cases be an option. Now that doesn't, that doesn't comport with what a lot of judges say about their psychology of sentencing. They say that just wouldn't look right. Okay. Another example is probation without supervision or administrative probation. During the model penal code drafting, we sent a team, I went with them to the New York City probation service or whatever they call it, probation department, and studied their system, see if we could help them, see what we could learn from them. And we thought they had a great system. We ended up thinking the best thing we can do with New York is just talk about the New York system when we're in other jurisdictions. But New York did what the model penal code recommends before we recommended it. They vastly cut their roles of supervised probationers. And they did it in two ways. They did it largely through some sort of risk assessment or sorting process. But a lot of probationers remained on probation, but they were simply on unsupervised probation. So the conditions still applied, the possibility of revocation is still there, but there's no one watching over you. A number of the New York City probation offices have kiosks in them, like ATM machines that a probationer every month can go and just enter some information about how things are going. But the idea of this was to move resources over to the cases where the resources were most needed or most beneficial. And they thought they had to cut the roster of supervised probation to do. The other thing New York did was they introduced a very widely used practice of early discharge from probation for supervised probationers who were doing well. Right? And they looked at the data. Most probationers were going to fail in the first year. Right? The longer they're on the probation, the lower the risk of recidivism and other failure. So someone who's doing well after 1 year or 2 years can be released. So the current, if I'm not mistaken about the numbers, the current supervised probation population in New York City is 1/3 of what it was before they made these changes. And the resources, we went to some of their probation offices and community services center, and the resources they had for probationers just didn't look real to us. Our team, we had experienced people who spent decades in corrections and community corrections who said, this just looks like the future. This looks like probation of the future, right? So,
Can I get Commissioner Reeves?
okay, I'm sorry to be long. I get so excited about New York because you don't always expect New York City to be, Rikers Island, you don't expect them to be the model in criminal justice, but in probation, I'll stop.
Thank you, Commissioner Reeves. So a couple questions. When you say probation without penalty, in your research that you talked about Canada and such and such, what offenses are you talking about, probation without penalty? I'm curious about that.
Well,
And
yeah,
another follow-up.
right. Well, largely it's property and drug offenses, right? And it's, if the judge thinks the person needs to be on probation because there ought to be services that could be offered that should be required, not optional, then you need probation. But if it's a nonviolent offense in particular, if some states use risk assessment instruments to identify defendants who pose very low risk of meaningful recidivism. And so those people become identified, well, we could make life worse for them, but they're already in a low risk category, at least for the first offender. Why don't we try this? Okay, so this is called a cut line. You know, if you implement this new sanction, where's the cut line between people who are eligible for it and those who aren't going to be eligible for it? And that's the most important decision to think about if a state has decided to authorize this penalty in the first place. Then the next question is, what's your cut line? What do we feel, if this went into the sentencing guidelines, what principles would you state to recommend to a judge, this is where this should be a presumptive sentence or a sentence that would not be a departure? Does that answer?
Yes, I'll say further comment about that particular question when we start talking about that. But the probation without supervision that you discussed, if they get administrative probation to the court, for example.
Right.
And in the example that you provided, did you see an issue with people that committed new offenses and they weren't catching them? Because that's what we see in Hennepin is people that commit new offenses while on administrative probation or probation to the court can get new offenses and we don't catch them, and they could potentially be a violent offense, and they may have a court date for several months before it's found. And even people that are unsupervised, I have a high-risk caseload, and I keep my unsupervised clients on my caseload, so they're still potentially being monitored. I get alerts and things like that. So I was just curious about that.
Yeah, well, this is something that has to be, discussed. I'll point this out later, or we probably won't get to it. But there's something about the United States. Everyone knows that we use the words mass incarceration for the fact that our prison rate is the highest or one of the highest in the world, and 5 to 10 times the prison rate through Europe or Canada and Australia, things like that. But we did a study in the course of the research for this of probation supervision rates in the United States versus Europe. And we compared every state with every country in Eastern and Western Europe. And what we found was that probation supervision rates, average across the United States, were 5 to 7 times the rates in Eastern and Western Europe. It's not just Western Europe, Western and Eastern. So this raises the question, does everyone who's currently on probation need to be on probation? Right? And I think you have to study this question within each state. Certainly the people who worked on the project with us had the opinion, yes, there's a meaningful share of people who are on probation who don't need to be there, or maybe needed to be there for a year or 2 years, but don't need to be there for 5 years. So the problem of the cut line becomes one of data and talking to practitioners, talking to people like you. We're seeing data from your office about revocations and rates of reoffending and so on. But there is a widespread feeling that we're doing probation somehow very differently from the rest of the world. And doesn't that at least suggest or raise the question that maybe we've got too many people on supervision? Okay. And apart from that, Minnesota has the 4th highest probation supervision rate in the country, right? So the United States as a whole is an outlier compared to sort of Europe, Canada, Australia. But Minnesota's like, you know, the probation supervision rate in Minnesota from the latest data is 70% higher than the average state in the US. Right, so again, it raises the question, do all those people need the same level of supervision they're getting? Do all those people even need to be on probation? You know, all I'm here to do today is to say the model penal code suggests that this should be a question that states take seriously and look into. And the goal would be to marshal resources so that you're not spending unnecessarily on people who don't need supervision. And you're moving those resources over to the cases where supervision is most needed. Supervision, you know, services and surveillance. Okay, so it's very similar to the principle for prison population. You don't want to be incarcerating people who don't pose any danger to anybody. You know, and again, you know, a lot of people in the field say, well, every state has a certain number of prisoners who don't need to be there on public safety grounds. Right? So is Minnesota one of those states? Is that true of probation? Is it true of prison? The model penal code just recommends every state should make sure they're prioritizing, they're thinking about this. They're thinking not just about total bed spaces, but are we prioritizing to the highest need?
I think Commissioner Fraze had a question and then Commissioner Crutchfield.
answered.
It was answered? Okay, Commissioner Crutchfield?
In defense of probation, having worked in Ramsey County, we do have a New York style system with a probation reporting center in Ramsey. And our friends in Hennepin not Hennepin, in Washington and maybe St. Louis are doing dosage probation.
Yeah.
They're trying to do some good stuff. My question is.
Yeah, I'd love to talk to you more about it because
Yeah.
you know, that one trip to New York City just left, and you know, and maybe they were pulling the wool over our eyes.
Oh, no, they're doing great stuff there, but Ramsey County has modeled it with a pretty aggressive phone or probation reporting center. And then they've also done some really interesting stuff with dosage probation in Washington, I think St. Louis, and I forgot what other counties, and Hennepin too. But my question really had to do with racial disparity. And do any of the overriding principles that you put in your model penal code, do any of them address the issue of racial disparity?
Yes, racial disparity is addressed in multiple places throughout the code, including the basic purposes provision. That what you saw on the slides was only, you know, 10% of what's in the purposes, but that I had a whole sequence of slides on disparities in this presentation. Hopefully we'll get to it. If not, you can invite me.
Like, stop asking so many questions.
No. The information exchange works better through questions than through the slides. But I can come back to your next meeting. I can come back as often as you'd like. And you know,
Why don't we have you go ahead and.
Okay, sorry.
This one, and then we'll see where we get today.
Okay. Now, in addition to public safety, the model penal code also takes proportionality of one of the two big basic tenets of the sentencing system, which is, again, similar to Minnesota. And the principle of proportionality is that you need to think about the severity of the offense, the blameworthiness of the defendant on the one hand, and the punishment imposed, the severity or the punishment imposed has to have a relationship of proportionality. So you've got two reference points. One is offense severity, and the other is sentence severity. Okay. Now, with respect to sentence severity, I think this is probably similar to the way proportionality is viewed in Minnesota. Proportionality means you're going to render sentences within a range of severity that's proportionate to the gravity of offenses, the harm done to crime victims, and the blameworthiness, the culpability of the offender. Okay, and the model penal code says all sentences should fall within a range where people would agree, okay, this is within the realm of proportionality. Okay, so it's taken seriously in the code. If the code has a master theme with respect to proportionality, it is that it doesn't actually operate in a lot of states. Maybe better in Minnesota than other states because we have sentencing guidelines, we have appellate review of sentences. But the observation of the drafters of the model penal code is, in an awful lot of places, proportionality is just window dressing. It's something people talk about, but there's no mechanism. There's no guidelines commission to make those judgments. Judges don't have the power or judges think about it in whatever way they want to think about it, each judge, okay? So proportionality in the model penal code is in relation to, as the Sentencing Commission sees it, it should be in relationship to ordinary cases of a given type. Now, where did we get this idea from? Minnesota. Okay, the idea that the Guidelines Commission, when it drafts guidelines, should be using its collective judgment. This says down towards the bottom, the commission should represent various constituencies in the system, and it should exercise its collective judgment on what's a proportionate range of sentences for various categories, for ordinary cases. Okay, so this is something that I think comes straight out of the Minnesota system, but Minnesota also says, and this may be relevant to some of the discussions in the review, that the guidelines are a collective judgment with respect to ordinary cases. But there are going to be a fair number of cases that aren't ordinary, that are aggravated or mitigated or move up and down from the range in the guidelines. So the commission's responsibility is to put the benchmark or to set a range. But that's a first draft of proportionality that judges should be able to vary from using their departure power, okay, in appropriate cases, right? Not too much. You have to govern the departure power, but there ought to be a departure power for appropriate cases, and this is just one of the provisions on judicial departures. Similar to Minnesota, a departure is authorized if there are factors in the case that take it outside the realm of an ordinary case within the class of cases defined in the guidelines, right? And reasons for departure have to be stated on the record. They're subject for appellate review under the code, just like in Minnesota. So it's not just judges making up whatever they want. The guidelines are enforceable. They represent the commission's collective judgment that there's room to move by sentencing. And this probably just sounds like I'm describing the Minnesota system. But the hope is that the guidelines will create judicial practice that has some resemblance to a bell curve distribution, where the majority of judicial sentences will be within the guidelines. But there will be some aggravated, some mitigated departure. And you want to have that, to a reasonable degree, because the commission can't perfectly foresee what individual cases would be. And this, you might want a left skewed distribution, so there are more mitigated departures than aggravated. That seems to be what every state guideline system has. But the idea is the guidelines are not written in stone. They're meant to create a bell curve of proportionate sentences, but judges have to sentence the case before them, okay? The code also speaks to ways of thinking about sentencing severity, right? If a judge is supposed to, and the Guidelines Commission is supposed to develop a sense of offense severity, offender culpability, what are the things to think about in terms of sentences, severity, and there are obvious things. What type of prison you go, prison versus probate versus community sanction. How long is the length of the sentence? What are the intensity of sentencing condition? But the code recommends that other factors should also be included when judges think about what's proportionate in an individual case. And we actually mentioned this in Q&A earlier. The judge should think about ABC, that even without any other sentence, the conviction carries a serious stigma. It's going to count as criminal history in the future, and usually hundreds and hundreds of collateral consequences are going to affect that defendant, some for the rest of the defendant's life. And those at least ought to be considerations in the total proportionality determination. Okay. Now, the last thing I'll say about proportionality is that I think the ALI was, well, and I was very frustrated at having a hard time finding an example within the American states of a sort of jurisprudence of proportionality. When is a sentence excessive on proportionality grounds, as opposed to it's just something up to the judges in individual cases. The constitutional law of disproportionate sentences hardly ever affects any sentences in the United States because it's a principle of gross disproportionality at the federal level in most states that hardly ever has any teeth. So what the Model Penal Code ended up recommending is that the appellate courts in each state system should have the ultimate power to rule on whether a given judicial sentence is proportionate or not. They have to take the guidelines into account. They have to take, other opinions into account. But there has to be someone who ultimately is in charge of the question, is this sentence proportionate or not at the end of the day? And the code's approach to this is this should be the courts. It should be the appellate courts generating a jurisprudence of not gross disproportionality, but just what does proportionality mean? And it should have some bite. It should actually affect some, a meaningful number of cases. And the provision that's in the code says that the appellate courts may reverse, remand, or modify any sentence, including a mandatory sentence, on the ground that it is disproportionately severe. This is a statutory proportionality review as opposed to constitutional proportionality review. And this provision was basic to the code from the original planning documents. Okay, I have to tell you candidly, there's no state in the country that has a provision like this. Right? This would be a substitution of a statutory proportionality power given to judges that would do the job that at least some people might have thought the constitutional proportionality power would be doing. Okay, so again, one of the ideas in the code for your consideration. Now, I should ask at this point, how am I doing on time before you have to move on in the agenda?
You're doing all right. I think if the max you could go would be 3 o'clock.
Oh, okay, good, good. So we'll definitely get to disparities. And I'll talk some about criminal history. Okay, another subject that's been in the room for this Guidelines Commission for a long time and is criminal history. And so let me say that, the code has a fairly long provision on criminal history, but let me give you a couple of the highlights that might, influence whether this should be more of a discussion here in the next couple of years. The code takes the position that the criminal history should be consulted when thinking about the blameworthiness of the defendant before the court. But judgments of blameworthiness based on criminal history have to be balanced against the fact that the defendant has experienced previous punishment for the prior conviction. Right, so if we believe the system is working even halfway the way it should, for that prior offense, there was in the past a proportionate punishment. So the degree of additional punishment when that same offense now comes back as criminal history should be, this is just meant to be a principle that a sentencing commission, sentencing judges as well, should recognize, well, this is a relevant fact, but there already has been punishment for this past crime. Okay, and so the provision that's in the code on this says that, well, if criminal history is used for assessing blameworthiness for current offenses, the commission shall consider. Okay, it doesn't, it's you know, an open-ended. The commission shall consider that offenders have already been punished for their prior convictions. Okay. The Minnesota sentencing guidelines, in contrast, I think this is a sort of different attitude. What the guidelines currently say is that the severity of the sanction should increase in direct proportion to an increase in offense severity or criminal history. Right? It treats both dimensions almost of equal importance, where the current conviction is for an offense that's never been punished. Okay, so I don't know. You know, this is day 11 of the project. I have a lot to learn about how Minnesota's system is currently operating, but there are certain admonitions in the code that perhaps the Guidelines Commission could think about. In terms of criminal history and public safety, the guidelines ask the question, is criminal history the best predictor of recidivism risk? We know it's a good predictor of recidivism risk, but is it the best predictor of recidivism risk? And the code makes the following statements. Sentencing commissions should give a due consideration to the danger of the criminal history provisions. I'm sorry, I skipped ahead. I skipped ahead to racial impact. If criminal history is used for purposes of assessing risk of reoffending, the commission should consider that the use of criminal history by itself may overpredict those risks. And I know the Rabin Institute has done a recent study of the criminal history score in Minnesota and made some good suggestions. But criminal history is not the best predictor. There are things that can improve upon it that the state of Virginia, for example, is doing in its Sentencing Guidelines Commission. Now, finally, criminal history and racial disparities. There's been conversation about this in this room over the last year. The Model Penal Code says the commission shall give due consideration to the danger that the use of criminal history to increase sentence severity may have disparate impacts on racial and ethnic minorities or other disadvantaged groups. Okay, now I've got a whole sequence of slides coming up on the idea of racial disparity versus racial discrimination. But again, all the code is trying to do is just elevate this concern, right, as something that every commission should think about. I think the Guidelines Commission here has been thinking about it. Okay. Now, on the subject of disparities, if you open the book here, I mean, Nate, you don't have to do it, but if you open the book to the introduction, the introduction contains a section where it sort of assembles just all of the different sections in the Model Penal Code that address problems of racial disparities, other demographic disparities. So it's a hand, if you just want to go through the code and see all of what it does, that's a handy place to start. I'll just, give you some examples. Minnesota has some very good things in place for racial, explicitly prohibited as a sentencing factor. Minnesota in, 17 years ago, it's 2024 now, was the first state to start generating demographic impact statements when the data supported them and changes in guidelines or statutes came forward. This is yet another way in which Minnesota is very visible to the rest of the world. First jurisdiction to do this successfully with credibility. Now, in talking about racial, other demographic disparities in sentencing, even geographic disparities, issues of terminology and measurement are really critical. A lot of, the code takes the position that, a lot of, arguments or overheated discussions just come out of the use of certain terminology. And the code makes the following distinction. Numerical disparities in outcomes are the numbers that we usually see. We can measure those numbers. But numerical disparities in outcomes are a concern. They're not proof that the system is malfunctioning. Okay, for example, more than 90% of people in prison for murder are male. That's a 90%, 9-to-1 disparity in imprisonment for murder in the prison system. Well, that's a numerical disparity. It gets our attention. Maybe we should think about it, but you know what? It just so happens that men are committing 90% or more of the homicides in the United States. So numerical disparities are a concern. They're a warning flag, right? But what you want to know on the other side of this line, on the right side of the screen, is the disparity based in something that's inequitable? Is it based on an unfair consideration? Is it based on bias or discrimination? Right? So the code, throughout the code says the commission and everyone in the sentencing system should be thinking about and acting to reduce inequities and discrimination on grounds of race, gender, religious belief, whatever. But numerical disparities are not proof that bias is operating or that an inequity is, okay? So I think the commission itself has had some conversations like this. Disparities are a consideration. The elimination of inequities or bias in sentences are what needs to be eliminated. Okay, if that helps. And the code offers some thoughts about the measurement of disparities and when we can measure improvements or reductions that I'm not even going to try to put in this presentation. I've talked it over with Leah and other staff, and that might come in later. But the basic idea, numerical standings disparity are a warning flag, right? A commission would be irresponsible if it didn't at least treat them as a subject of concern. But then you dive deeper, okay? So here's just examples of the different use. The model penal code, it treats numerical disparities as a cost. I mean, if we could, we would live in a world where there was no numerical disparity. We would all but it's a cost that must be considered along with other factors in deciding whether change is needed. When the model penal code identifies what should be eliminated, it's discrimination or inequity, unfairness in the system, bias in the system. Okay, so these are very careful word choices that help the analysis along. Okay, because otherwise there can be people in the same room who mean different things by different wording. Okay, one of the commission's largest recommendations on racial disparities is that, I'm sorry, not the committee, one of the model penal code's most forceful recommendations on racial disparities is that states should generate a capacity of demographic impact projections. Okay. Minnesota was the first state to take that recommendation and implement it. I presented to this commission in 2007, and within the year, the commission had implemented the demographic impact projection that you've been doing ever since. Okay, first state to do it, but that was something that came from the model penal code back in time, long before the project was finished. In addition, something that might just be worth thinking about, the model penal code recommends that in the list of official mitigating factors that judges should consider when sentencing an individual, there ought to be a mitigating factor for circumstances of hardship, deprivation, vulnerability, or handicap. Right? This is not affirmative action, and this isn't key to demographics, but it captures a lot of what some people are concerned about. That there are some people who come before the court whose offenses, their blameworthiness should be mitigated by the fact that they never had a chance, they grew up in circumstances of hardship, deprivation, vulnerability. And the code, this is the code's language. The code says the personal characteristics of the offenders may be included within the guidelines when indicative of circumstances of hardship, deprivation, vulnerability, or handicap. Okay. Even though, like Minnesota, the code says race cannot be used as a sentencing factor, gender can't be used as a sentencing factor, religious belief, but notwithstanding that, the first lines in this provision, personal characteristics may be included here. So something to think about. Personally, I would like to think that, I would like to see this added to the list of mitigating circumstances in Minnesota. Okay. But as I say, there's a lot in the code about racial disparities. I'd be delighted to be invited back and simply talk to some of these issues that I've raised today, but talk in more detail. Now, departures and departure rates are another subject that the Commission mentioned quite a bit in terms of the comprehensive review. So I just want to outline the model penal code's view on departures. The model penal code welcomes reasoned departures. The model penal code view, and I think it's the general view in Minnesota, is that a departure that is justified by circumstances in an individual case is the right sentence. Right? You wouldn't want the judge to give a guideline sentence if there are substantial and compelling reasons, given the purposes of sentencing, why a different sentence is better. Okay, so the model penal code welcomes reasoned departures. The appellate courts are in charge of policing this. To some extent, the Guidelines Commission is charge of policing, but the basic bell curve attitude is that departures, the code even says this in commentary, departures should never be described as non-compliance with the guidelines. Because a judge who's doing exactly what they should in a guideline system should depart when the departure is justified. It's compliant with the guidelines if it's a justified departure. So the code, welcomes a judicial discretion to individualize in light of the purposes of sentencing, subject to the presumptive force of the guidelines, subject to appellate review. On the other hand, the code says, well, judicial departures should be monitored by the Sentencing Commission. and treated as feedback. It's treated as signals or considerations of possible problems that should be addressed. If departure rates are moving up and up as they are in Minnesota, as they have been in Minnesota, does that mean that something in the guidelines should be changed? Because you're getting all this information from judges. It should be treated as feedback. So the model penal code, this is again language from the book, says the commission shall study the need for revisions to the guidelines to better comport with judicial sentencing practices and appellate case law. Okay, again, I think that's not telling you anything that you don't know or haven't been doing for years, but this is a general attitude that I hope the comprehensive review will continue. Now, there were two other subjects that I wanted to raise today. Maybe I have time to say something about each one. I've already talked some about probation and post-release supervision. The model penal code requires that state sentencing guidelines speak to probation, post-release supervision, economic sanctions, okay, in addition to prison and jail. Okay. In Minnesota, the statutory mandate to the Sentencing Commission says the Sentencing Commission may, at its option, create guidelines for non-prison sanctions. Okay. So the code takes a more forceful position that I guess could be interpreted, if speaking to Minnesota, you should consider doing something about introducing the guidelines into the consideration of probationary sentences, and I'll give you some examples. But as I said before, probation supervision rates in America, just in the dimensions of probation of supervision compared to other countries, people are starting to call it mass probation. I mean, the term mass incarceration has been around for more than 20 years, but especially in response to the research that we did, people are starting to call it mass supervision. Hold on a second. Oh, I'm sorry, I'm going the wrong direction. That's why I can't find my slide. You can't read the slide, but this is the study that we did in 2016 of U.S. probation supervision rates in all 50 states versus European rates in Eastern and Western Europe. And the short way of looking at this is that the orange lines on the graph are the probation supervision rates in each of the American states. The light blue lines on the chart represent the probation supervision rate in entire countries in Eastern and Western Europe. Okay, the blue line to the furthest left is Turkey. Compared to other European countries, they have a lot of probation. But just zooming in, these bright yellow lines are the averages for Europe versus U.S. The U.S. average probation supervision rate was 16.05 per 100,000. The average European rate was less than a fifth of that. If you just look at Western Europe, right, we're more like 7 to 10 times higher than probation supervision in Western European countries. So that the size of the use of the penalty is just as different as the size of our prison population. And this research has been very influential. We were working with a number of probation departments, not just New York City, but whole state of Massachusetts. And we encountered people who had been in probation, that made their careers, have been chiefs of offices and so on, who had no idea the probation supervision rates in the U.S. were so different from other countries. Just, there was one guy who's, I think, is still the chief of Massachusetts probation, who practically fell out of his chair. He said, I've been doing this for 30 years. I had no idea. So it's information. It doesn't tell you what to do, but it's useful information. And as I said, Minnesota, among these lines on the graph, Minnesota in this, oops, I'm pushing the wrong arrows again. Minnesota in this year had the fifth highest probation supervision rate. Now it's the fourth in the most recent statistics. And its current supervision rate is 70% higher than the average state. So these are things worth thinking about. As I also said earlier, the code's view of probation and parole supervision or post-release supervision is that resources should be moved to where they're most needed. That's kind of the master principle. That means there's some people on probation that shouldn't be. Probably that means that the intensity of conditions and supervisions could be shifted to where they're most needed. But this is just from the commentary of the code. If there is a master principle behind the policy choices in the probation provision, it's the need to prioritize the use of scarce correctional resources. Why? We want to maximize the sanctions public safety benefits. Right? So it's part of a sort of evidence-based attitude. Let's put the resources where they're most needed, where they can best serve their intended purposes. Okay, the Model Penal Code identifies what it thinks the purposes of probation should be. First, hold offenders accountable for their crimes. Second, promote their rehabilitation and reintegration. And third, reduce the risk they'll commit new offenses. Okay, so there's a services, rehabilitative side, and there's a surveillance crime prevention side. I don't think these are radical statements of the purposes of probation, but states can have their own view. The code goes on to say the court shall not impose probation unless necessary to further one of these purposes. Okay, we went over some of this earlier, but this is meant to just structure the thought process of judges. Okay, there's another provision that kind of speaks to this. It has sort of three admonitions, but the most important one addressed to judges is be careful that you're not using community corrections resources for unnecessary probation sentences when they could be preserved for cases where they're really needed. Okay, we have an absolute catastrophe and crisis in under-resourcing probation throughout the country. Okay? These are at least ways that the Model Penal Code has tried to address it. We've already gone over this question that Judge Larkin asked that is the $64,000 question. In cases where probation is not warranted, what do you do? Community service orders, day fines, unsupervised probation, unconditional discharge, which is already used in these jurisdictions, are things worth considering. Probably a state could think of other options that could be available in their jurisdiction. But as I say, this whole presentation is just throwing out some ideas, the kind of ideas that are in the code that might be valuable to think about. The code addresses conditions intensity in a number of ways, but the most important way is hearkening back to the do no harm principle. Right? When a judge imposes probation conditions, or when if it could be a parole board in lots of states, no conditions should be attached to probation that would place an unreasonable burden on the offender's ability to reintegrate. Okay? Don't make it harder for the person to maintain a law-abiding. Impose necessary conditions, but think about this too. The do no harm principle in that book keeps cropping up in the code, okay? Early release from probation terms, we mentioned this is something that New York's doing. The Model Penal Code recommends that in the ordinary case, a probationer who does well for 12 months should be discharged. That ought to be the presumption. Okay. Maybe that's the wrong number. Maybe experienced professionals in each jurisdiction would say, no, not in this city. But the code advocates early release for probationers who are doing well. Again, let's save the resources for the people who most need it. Post-release supervision terms, parole supervision in most states, is another area where a lot of these same problems that you could see in probation come up. But there's one that specifically has to do with post-release. And that is, in Minnesota and most states, the duration of the post-release supervision term is what is left of the total sentence when the prisoner is released. Okay, so in Minnesota, prisoners most of the time are released at the 2/3 mark. They have 1/3 left to serve. Okay. In a lot of other states, the parole board decides when you get out, but then your post-release supervision is whatever remains. Okay. And the code says that's not the way to do it. When the judge imposes a sentence, the judge should impose the prison term up to presumptive release, and then it should be the judge who decides the length of the probation supervision term to follow. Okay, so it's not one size treats all. The Model Penal Code said this in 1962. This is from the original code. The length of post-release supervision should be set in light of the individual case, what's needed in the individual case. Maybe you could have a strong presumption that it's 1/3 of the prison term, but that's going to be an awfully long time for some people and an awfully short time for others. So uncoupling of the two, the Model Penal Code language is the length of post-release supervision shall be independent of the length of the prison term served or unserved. It's just a conceptually different way of looking at it than in Minnesota and in most other states. But there are states that take the Model Penal Code approach. And as I said, early discharge is an issue in post-release supervision. It's an issue that overlaps with probation. Now, the last thing I came here to kind of talk about to illustrate the kinds of things that are in the code is economic penalties. If you recall, the code says every state sentencing commission, it ought to be mandatory that every state sentencing commission address probation, economic penalties, post-release supervision. This commission has that statutory power, but it's discretionary. It's that provision I had on the board earlier. The commission may generate guidelines on these subjects. The code takes the view this is important for some different reasons, but one of the primary concerns, frankly, is public safety. No country in the world imposes economic penalties that are as heavy as those imposed in the United States. Okay, it's hard to measure because you don't have like a prison rate that you can compare, but when you study other systems, when you talk to practitioners or judges in other systems, when you tell like a judge in Canada all the things that kind of get piled on top of the average defendant or person serving a sentence in the US, they just kind of shake their head. They say, isn't that counterproductive, is what they usually say. And isn't that exactly what you shouldn't be doing? Is people are trying to get back on their feet. They probably didn't have much money in the first place. You're probably not even trying to collect those penalties that you're imposing in a lot of cases. All you're doing is pushing them down and making it harder for them to, so the do no harm principle was very important in the code's treatment of economic sanctions, that this ought to be thought about, that economic penalties, when they're unrealistic, can be barriers to rehabilitation. They can be criminogenic if they force people back into the criminal marketplace, crime marketplace.
It's criminogenic.
Criminogenic, they can create crime. Right? You can give someone that penalty and make it more likely they'll offend in the future. So, the code addresses this in various ways, but the most important, something that could be put into sentencing guidelines in legislation, is the idea that when you sentence someone, you've got to leave them in a condition of reasonable financial subsistence. Okay, I don't like that term, but no one could think of a better term. But here's the provision. It's a short provision. No economic sanction may be imposed unless the defendant, the offender, would retain sufficient means for reasonable living expenses and family obligations after complying with that economic sanction. It's a little bit like bankruptcy, personal bankruptcy law. There's a certain minimum subsistence level that people need if you're going to halfway expect them to get back on their feet. Right? And when the judge imposes the sentence, the judge should be thinking, okay, I don't want to push this person below that line because that's counterproductive. Okay. And the ALI felt so strongly about this that they even included victim restitution. Among all the economic penalties, the ALI said victim restitution should always come first. Okay? But if the payment of victim restitution is unrealistic, if it would put the offender in the position that, or the defendant or the, released from prison or whatever, in a position where they couldn't live, right? Then it's probably causing harm, right? So that was, the ALI overwhelmingly, I couldn't believe it, voted to exclude victim restitution under this principle. Okay, so an example of something that went into the code. The model penal code also recommends just flat out that a criminal defendant's offenders should not be required to pay correctional fees, be that probation fees, drug testing fees, public defender fees, fees for the jail time. The code says no convicted offender, this is the recommendation, should be held responsible for the payment of costs, fees, and assessment. And the basic reasoning for this, just two parts, we're not, by and large, we're not talking about overwhelmingly, we're not talking about a wealthy population here. And besides, criminal offenders are the worst possible people to sort of identify as a special class of taxpayers who are going to pay for the basic provision of government services or government operations. Okay, restitution, code says first priority. Fines, fine, as long as you don't push people down that's below that subsistence line. But costs and fees, the experience across the country, we've studied this heavily, is that costs and fees tend to, I'm not saying this is true in Minnesota, but in many jurisdictions, tend to get way out of hand. Okay. Often the entity collecting the fee is the entity that's getting to keep the money and benefit from the fee. It's a serious problem. So whether it's something for the comprehensive review, I don't know. I could think of several other subjects that could be part of the comprehensive review that the code speaks to extensively. How do the guidelines interact with mandatory sentences? Minnesota allows departures from mandatory sentences in some instances. The code adopted that from Minnesota. It stole it from Minnesota. The code says that should happen. The code recommends a second look resentencing process after 15 years for extremely long sentences. Code speaks about different ways to decarcerate low-risk offenders. Code makes suggestions about special considerations for the sentencing of juveniles who are sentenced as adults. the code, and I'm sure everyone in the room and staff have all sorts of ideas about information or research needs that we currently don't have in Minnesota. I've got some priorities on my list. Code says the guidelines should cover misdemeanors. Is that even within the, one of the things that's been, one of the things that's important to a successful sentencing commission is that they don't try to do too much. If you try to do too much, then you're not good at anything. So I think Richard Fraser and I disagree about this, but I've always, wondered if it ain't, but anyway, this is, these are things that the code says, and probably hundreds of others that may be useful to this process. The code isn't really a code, it's just ideas. But one of the reasons the funder gave us $1 million to help you is, at least for my part, was that I had a big role in preparing the code, and hopefully that would be helpful. So let me know if you'd like me to help in this way or in completely different ways.
One of the,
Where do we start?
yeah, I know. Yeah, you want to give them an applause? One of the things that having been on many projects that purportedly do research, I always really appreciated that every line that went into the code was thoroughly researched. I mean, I was lucky enough to be at some of those meetings where you were considering particular provisions, and you always had the landscape of what the options were that people had used, and any information on what the implications of those things were. And so that's why it's this long. And it's extremely well researched. So I mean, I think that we all recognize that what we heard today was like the tip of the iceberg. And, I hope that you'll come back for whatever specific topics we're hoping for a deeper dive. I hope you're willing to do that.
Yeah, no, I'm glad to do it. But I should say the code itself, the actual statutory language, is like 60 pages. Everything else in the book is explanation, background, history, comparing other states and other countries. So, it's quite possible to read the entire code in one sitting.
Excellent.
But thank you for having me.
Thank you.
Thank you. Thank you so much. Thanks.
And Madam Chair, Professor Wrights and/or the American Law Institute has donated several copies of the Model Penal Code sentencing to us. So to avoid gift ban problems, we're structuring these all as donations to the Minnesota Sentencing Guidelines Commission. So these are state property. If you would like to check out, you being the members of the commission would like to check out a copy, please see me after the meeting.
Yeah, and I would
They're so
encourage you to
valuable,
do
we're
that.
going to keep them back at the cells.
Well, they are valuable, actually.
Right.
I think we're still seeing that
Yes,
presentation.
usually
Oh,
when
thank
you
you.
know, there's a good reason. Yeah.
All right, well, hopefully, the main goal of that was to jumpstart your thinking. I hope that was helpful for that purpose. We will definitely start getting into some brass tacks over the next couple of meetings about where do we want to start, and also what questions do we want to pitch over to the University of Minnesota research team to start bringing us material back for consideration. So hopefully that jump-started your thinking. But for today, what we have to do next is to take another look at the objectives and principles language. If you wouldn't mind putting that up. We had MAD facilitating this discussion over the last couple of meetings, and they took another stab at trying to write up the objectives and principles today. And I just wanted to get a read from the commission on, do we think we've gotten to a place where we can be comfortable with the language that they've come up with? So up here right now, on the screen, the place where we really were spending the most of our time last time were the objectives of the review. And so taking our feedback from the last meeting, here's what the committee, the MAD came up with. 4 principles, with the 4th one having a couple of pieces to it. So the first one is, so basically, because of the comprehensive review, number 1, the public and the commission are confident that the review process was transparent, inclusive, and thoughtfully executed. Number 2, practitioners find the guidelines are easier to understand and use. Number 3, the presumptive sentences for offenses are proportionate and fair. And number 4, relative to the current guidelines, the revised guidelines contribute to improved public safety, more consistent sentencing, and decreased disparities. Just looking for a reaction. What do people think of that? I see 2 thumbs up.
I'm just wondering, what does more consistent sentencing? The more uniform sentencing, is that what we're striving for? Is that more, or this sense or feeling that the guidelines must or need be followed? I don't know what that means or what that gets us. The uniformity part is to provide that fairness across the state.
Yep. Let me see. It's a good question. I'm trying to think. I thought I had the old ones on my system, and now I'm like, I feel like I just can't remember what words were there before. Oh, here we go. Oh, it's interesting. We had consistent sentencing in there before. They didn't change anything. So that, I don't know. I mean, I think it's open for interpretation. It's obviously for us to, if that's not a meaningful phrase, we definitely could change that to something that is more meaningful. And I don't know if uniformity is a concept we have. I mean, uniformity is a concept we have in the guidelines now. Is that something that makes more sense here, or just consistent just mean that in general sentences are being sentenced in the same manner? I don't know. Commissioner Grace?
Sure. I have no problem with that. My first thought was that the 2 of these things are just the same thing, consistency and disparities, being opposite sides of the coin. But I think what we're stating here unavoidably are goals that are in conflict with each other sometimes. So, consistency could mean, fewer departures if we, all things being equal, but sometimes, as Professor Rice was emphasizing, a departure is the right sentence, is the more proportionate sentence. A failure to depart could actually represent disparity. So I think you just have to recognize that these things are sometimes in conflict with each other.
Sure. Commissioner Luck?
Didn't we have a discussion about the difficulty with using improved public safety, more consistent sentencing, decreased disparities? In other words, how would we measure improved public safety? How would we measure decreased disparities? I thought we talked about, these are important concepts that need to be there, but can we really tie it to a measurement? Am I misremembering that?
Well, we had talked about, we did talk about that. I think that we had also talked about the fact that as we continue along with the review, we should have a discussion directly about how would we measure some of these things so that we know that we are meeting our goals.
Okay.
And I think that does really have to be one of the things we deliberately talk about and think about and lean on our staff to bring us ideas for. To me, what was different here was this phrase of like relative to the current guidelines, the revised guidelines contribute to these things. And I thought that was interesting because I think what it sort of recognizes is that, you know, we already see some issues, not necessarily, it may be with the guidelines and it may be with how they're applied. It may be, there could be many reasons for why some of these issues come up, but we see them. And so would the changes that we make impact any of these things? And I think that's ultimately what we're after, is trying to make changes that are meaningful in these ways. That was my interpretation of the way that they put it together, and that worked for me. Was there someone over here that raised their hand? Commissioner Sextina?
I did. Thank you. I don't know that this is all that helpful, but I'm recalling that when we were talking about consistency for that second bullet point, I thought we may have been talking about consistency in the application of the guidelines as opposed to consistency in sentencing, but that might be redundant with number 2. So I also don't know what consistency in sentencing means. That's my best recollection.
So a more consistent process rather than more consistent outcome.
I remember us having a discussion about that, but I'm not sure if that's the origin of that language.
I thought consistent sentencing had to do with if that chord was Century Avenue, and I'm on one side of Century Avenue and I boost a car, what happens, how I get sentenced versus if I go to the other side of Century Avenue in Washington County and boost a car, what my sentence is, and whether they're consistent across all of our 87 counties, where there's some counties that look at crime differently than, you know, the metro or whatever, but
I guess so, Commissioner Reese.
Thank you. Inadvertently look at that term, more consistent sentencing is more transparent sentencing. Because I think when we're talking about how someone gets sentenced across the street, I think when we're in the public, we're looking at what we see on TV or in the courtroom. We're not looking at big picture like criminal history score and those type of things. So I look at that a little bit differently. I understand we need consistent sentencing, but it could be looked at so many different ways that it might help us be more transparent when we're talking about sentencing. Because once you break it down, people understand, oh, I get it now, as opposed to, oh, I don't understand why it seems like this person's getting this and this person's getting this, when there's more things in play besides what you see in the courtroom. And we do this process and really engage community in sentencing.
Maybe it's good that we don't have a common or understanding of it, and that we, as we go through it, we wrestle with what does that mean, examine as we go along, possibly.
Yeah, I was just about to say, you know, maybe a little bit of lack of clarity right now is okay, because we are trying to figure this out, and we are trying to, and we want to figure out how to measure things. I guess my question is like, building off of the way Matt did it last time, are we in I could live with this stage, at least?
Yes.
Everybody there. Commissioner Mueller?
Hey, good afternoon, everyone. I just wanted to speak up. I am now in a position where I can live with this for sure. I agree with the last comment that maybe it's okay that we don't kind of all see eye to eye. These are just guiding principles. And just the comments I'm hearing, I think we're all driving towards the same end results. We all understand what we're trying to accomplish. And so I think it'll make for good conversation using these principles as we start drilling down into the guidelines. So I'm good with it.
Right. I'm seeing head nods in the room. Do we need a motion, or do we just want to move forward without a motion today? How do you want to proceed? You want a motion
I
done?
think we lock it in, Madam
All
Chair.
right, let's do a motion.
Take the win.
I would entertain a motion to approve the objectives.
Second.
Did Commissioner Reeves is making the motion, and then who's seconding that? Commissioner Middlebrook. Any further discussion on the motion?
I just have a question.
Oh, Commissioner Larkin.
And I think Nate had brought this up. If we do adopt this today, is this something that could then go into the report to the legislature to show progress that we've made?
Yeah, I think that's valid, sure.
I think you mentioned it would be nice.
I did, I'd kind of given up on that dream, but you're right.
It'd be nice to say you've got a plan, so, all right, yeah, good.
Okay, great. So I know someone's working tonight.
I think that's an easy one, right?
Yeah, that's.
I think so.
Any other discussion on the motion? All right, hearing none, we'll take a vote when you're ready.
To the Reeves motion to adopt the MAD drafted comprehensive review objectives dated December 21st, 2023. Larkin?
Yes.
Larkin, yes. Crutchfield?
Aye.
Crutchfield, yes. Fraze?
Yes.
Fraze, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Moran?
Yes.
Moran, yes. Mueller? Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 13 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. That's amazing. No, that's great. I'm really excited that we were able to come to a middle ground there. The other piece of the document is principles. I don't recall us having too much discussion on this last time, but I don't remember if it's because we ran out of time or we didn't discuss it.
We ran out of time.
We didn't discuss it.
No, we ran out of time.
Okay, all right, so I don't know how we want to walk through this today.
Well, I mean, it
Let's
seems
just
like
walk
a
through
big
it.
chunk. Yeah, we can walk through it, but it seems like a lot to ask to
Yeah, no,
come to a
let's,
consensus on this in 15 minutes.
let's just walk through it today and start. We have 15 minutes, so let's just take a little bit of time to do some discussion. I'm not your mad facilitator, so if I do badly, then just give me a little grace here today. All right, so the first item here was principles to guide research activities, and the first principle here was with regard to data sources, that we should be open to refining our original data set if questions arise. I interpret that to mean that we would be looking for other data or information if we find that we don't have what we're looking for or what we need, that we would seek broadly sourced and reviewed research and data, that we would recognize data challenges, that there can be bias or occasional lack of complete or probably should be inaccurate data, or maybe the data is not always complete or accurate.
I think that's lack of, yeah.
Yeah, and that we should draw deeply from Minnesota court system data where possible, rather than relying on theoretical models. And then also first sticking on data resources. Any questions or comments there?
And
Commissioner Larkin.
I assume this means we'll look at data on both sides of the issue where there is disagreement?
I would assume so.
Broadly sourced.
Broadly sourced. I think that last bullet, I assume the last bullet is, not trying to make a point with data from research projects that have been done in other places could inform our work, but may not be reflective of what's going on in our state. I think that that's probably what the person is saying there, or what that bullet is trying to capture that we may have been concerned about. Other discussion or thoughts there? in terms of, let's see, what's the other one? Applicability, make data easy to understand and apply, use data to examine racial impact of potential policy decisions. All right. Just going on. I'm just wondering, were there, does that seem to capture the ideas that people had when we were trying to think about what principles should guide the way we do research? Or does anything feel like it's missing there? Okay. All right, next one, next set of information. Principles to guide our interactions and preparation. We should be thoroughly prepared for meetings, which apparently I wasn't because I didn't read this very closely. We should seek a common understanding of what terms and phrases mean. Mindset. We should balance philosophical approaches with achievable outcomes. Do right by all Minnesotans rather than just your constituencies. So try to think about applying that more broadly, your perspective. Probe conventional wisdoms. For engagement, assume good intentions. Oh, I'm sorry. Did you have a question?
I'm sorry to interrupt you too, so I'm happy to wait if you want to wait.
No, go for it. Go for it.
I just wanted to suggest on the second bullet under mindset, I'm perfectly fine with the first part of it. I'm not sure what constituency means as a member of this commission. I think our constituency is all of Minnesota, regardless of why we're on the commission. And so I might suggest taking it out because if somebody reviewed it, it might not make much sense to them how the commission works. But I'm curious if others have a different view of what that term means for this organization.
My read on that would be, like, I'm here, I represent DOC, the Department of Corrections. So you wouldn't want me to come to a decision just because, you know, like, that's going to affect the Department of Corrections in a certain way. You would hope that I would bring that perspective. This is how it will affect corrections. But also when I think about Minnesota, I think it would be a good decision even if it negatively affects Department of Corrections, right, in some way. So I think that's what that's asking for. Commissioner Larkin?
Would stakeholder be a better word?
Oh, yeah.
Maybe not,
Would
but
that work?
stakeholder group, I think. Constituency sort of implies like you're beholden. I have to represent you. Stakeholder group, I think, maybe a little bit different. If you're talking about the interests of that group.
Also, not all of us have, I guess
Right.
I'm a public member, so I don't have a constituency. And so maybe that's why I was focused on the term.
Yeah, yeah. Should we change that to stakeholder group? Would that be better, or?
Sorry.
I'm fine with changing the stakeholder group because I was thinking along the same line that you were, that I represent probation. I don't want that to bias the entire population, whether they're in custody or what that may look like, but I'm fine with stakeholder group as well. It did kind of remind me of an elected official when I first.
Yeah, that's true.
Yeah.
Commissioner Ladd?
I was going to say exactly that. As an elected official, that's what it felt like. And obviously, my role on this commission is because of that. But that isn't sort of like the people that voted me in Waukegan County, well, they care about this. That is not the focus. So I do think the wording does matter. And so I would agree that stakeholder group probably would be more appropriate for everybody that's on here, regardless of what their role is in terms of the appointment.
Yeah. Commissioner Larkin?
And just wanted to, maybe it should say rather than any stakeholder group, because maybe that's sort of broader and it kind of covers those people that don't feel like, well, I have a group of people I'm going back to talk to. I don't know if that helps, just a thought.
Or maybe rather than a particular stakeholder group. Do
Yeah.
right by all Minnesotans rather than a particular stakeholder group.
I just mean to get rid of the word your, because that kind of
Yeah,
then brings you back to I'm answerable, I have to vote a certain way.
okay, we can make that change. Okay, moving on down to engagement, we should assume good intentions. We should avoid dogmatic or triggering language. Listen to thoughtfully consider diverse opinions, experiences, and backgrounds. Be willing to reevaluate strongly held views when circumstances justify doing so. And then the last section, I'll just read it real quick for decision making, then I'll get to your input there. Strive to build agreement rather than win with simple majority votes. Be respectful through disagreements. Be informed by best and other successful practices. Commissioner Larkin.
I just think we're missing an and.
Oh.
In the bullet list, should it be listen to and thoughtfully consider diverse opinions?
Oh, I even read it out loud and I didn't hear
one of
the
those
mistake.
ones.
Yeah, no, that's true. Yes. Very good catch.
Just
All right.
an edit.
Anything else stand out to people? Commissioner Moore.
This may be a minor wordsmithing point, but strive to build agreement. Would consensus be appropriate there? I mean, there may be situations where people don't necessarily, 100% agree with everything, but they're, for the sake of the good of the order, they're willing to be involved with that. I just don't maybe want to frame it as all or nothing. I don't know. Maybe I'm reading more into that than is there. But as I looked at that, I don't know. I mean, that we may have situations where I think there likely will be give and take on things, and the consensus is what we should be looking to achieve there. Just a thought.
Yeah, you could change that to consensus. Change agreement to consensus. Okay. Commissioner Frace.
Oh, I already had written in consensus instead of agreement. I agree with that. One could also say rather than settle for simple majority votes. I mean, win does kind of put it a little more, confrontationally. But there is a difference between saying all we need to see is who's in the majority versus can we reach consensus.
Commissioner Larkin.
Maybe we just need to say strive to reach consensus without the, rather than win with simple,
I like that.
Yeah, I think that's a
Yeah.
good suggestion.
Yeah, let's make that change. All right, any other thoughts?
Can I go back up to mindset? I just was having
Yes.
troubles with my computer. So the suggestion was to replace your constituency with a stakeholder group. Is that right?
Yeah, so
Any stakeholder.
Any stakeholder group, okay.
with I wrote change consistency to a particular stakeholder group. Now I'm like losing it. Do right by all Minnesotans rather than a particular stakeholder group
Particular
or
stakeholder.
Any particular
stakeholder group? Now we're wordsmithing.
I wrote down any, but they all work.
You wrote down any?
Yeah, they all work.
Okay, so any particular stakeholder group, okay. All right, any other thoughts on these principles? Would you like to see the revised version next time and then we can approve them? Okay, perfect. That's what we will do. So you can't put those in the report yet.
We don't want to be overachievers.
Right. But the objectives will be a lot. That'll be good. Okay, I think that brings us to the end of our agenda. So to the public input stage. Whenever you're ready.
Yes. All right, so let's see, are we,
I don't think that's secret. Did we miss the executive director report or?
Oh, did we have that on? Did that? Yes.
yeah, what, thank you, Madam Chair, but to the members of the public, if you do have a comment, this would be a great time to raise your hands. It looks like everybody's should be able to raise their hands. I'd ask any staff members online to raise your hands just to confirm that that's working. But So raise your hands at this time and we'll get to you after the executive director's reporting. Just a couple of things to report. One is I did get my letter from the campaign finance board. It looks like this. There's a yellow sheet here that has all the changes this year. I actually didn't find it too onerous. I, in fact, did it right before this meeting while I was sitting here. And it didn't take too much more time than last year. If you did not get a letter from the campaign finance board and you are a member of the Minnesota Sentencing Guidelines Commission, please reach out to them. It is due by January 29th.
I thought these changes were vastly different.
You did find them different, okay. Well, maybe I just didn't have them, but.
Well, because now what they're adding is all this spousal requirements that they've never had before.
Okay.
And I'm really confused with the language that they use in those final paragraphs as to what we're really supposed to report with respect to our spouses.
It wasn't, we didn't actually end up reporting that much. At least that was, I didn't.
Yeah, I don't know. Maybe it's just my situation's very simple.
Oh, yeah. That's interesting because when I first had to do this, I contacted them and said, well, what if it's in my husband's name? It's not mine, but it's marital property. So technically it's mine. And they're like, nope, you don't have to report it. And I said, well, that seems like a big loophole. So now they're having us report our spouses.
These are major changes regarding spouses.
This is
the first time.
Yeah.
These are all effective January 1st of 2024. So these 8 changes listed here on this yellow letter are made of.
Wow.
So, but anyway, please make sure you do this if you're a member of the commission by the 29th.
And when you do it, they automatically upload it online. Because mine was right online when I Googled my name.
I've stopped Googling my name so long. So the second thing I had to report, so we are about the anniversary of us being short-staffed, and then we lost a second person due to retirement in the middle of the year. So I'm happy to report that we're deep into the selection process, which is being led by our new research supervisor, Leah Bauer, and I'm just delighted with, I don't know how she found these people. We got a really good crop of applicants that we're doing second interviews on this week. It's really been a pleasure meeting these people, and I'm looking forward to making the difficult decisions of who we're actually going to be hiring and bringing those people on board. Hopefully, hey, optimism is free, and maybe by next meeting we'll actually have some new members. So that concludes my report, Madam Chair.
Awesome. Glad to hear it.
And I don't see any hands raised from members of the public, Madam Chair.
I do not either. All right, well, that concludes our agenda for today. Unless there's any objection, I will adjourn the meeting and we'll see you in February. I should know the date, but.
8th.
The 8th, February 8th. We'll see you on February 8th. Thank you, everyone.
Thank you.
Well, late, of course, anyway.
Well, I feel guilty because I was the one that called, like, this is sort of.
I'm going.
It was the first time. No, and the first time that we had to do this.
I wanted to introduce myself for the order. Nice to meet you. Nice to meet you.
That's sad to hear. I've never done, no.
First day that you were a new member of the commission were here, and I was